First of all, as I was saying, if you heard or didn't hear, I really appreciate being here at the Family Institute. I've had the pleasure of watching the institution grow over the years. For me, as a lawyer working in family law, it's a tremendous resource to be able to refer clients and their families to the Institute and know that they will receive highly professional treatment, and which is really helpful because all that we want to do, all of us who work in this field, is to help the family rehabilitate itself. And to that end, it's extremely important that we have resources in the community we can trust. I'm going to speak about the navigating the family law system. I am going to touch on or more than touch on, issues that deal with abuse per se, but, okay, since I don't do 21st century, I've got my markers here, but I do want to give some background here. If I'm saying things that everybody already knows, you can let me know that, and I'll move on. If I'm using terminology that you're not familiar with, please let me know that as well, because lawyers and judges have a particular problem that they assume everyone speaks the same language that they do. So please let me know. I will leave room for questions at the end, because I'm sure that some of you will have questions as a result of the things we discuss here today, as well as from your own personal or professional experiences as well. So I handed out a sheet, or I gave you handouts that really, what's on them is particularly pieces in the first section, in any case, pieces of legislation that are very important to be aware of. It's also very important to be aware, and this I say to every therapist, you're not lawyers. And it's very important to know when to refer questions to the outside. Sometimes I'll get people coming to me and say, my therapist said, the mediator said, who's not a lawyer, the police officer said. They are not qualified to give legal advice. So it's very important to know, to have knowledge of what the law is in very general terms, but to also know, each of us, as I sit with clients and I say, I'm not a psychologist. This is a question for your psychologist. It's not a question for me to answer. So it's very important for all of us to know what our professional expertise is. Having said that, it's very important for you to know if working with families, what's going on in the legal world in the state. So, as most of you are aware, I'm sure, there are two more or less parallel systems in the state of Israel that deal with family law. One is the family court, and the other is the Beit Din Rabbani, and we'll talk a little bit about some of those differences where it's important. The most important development in Israel in the last couple of years in terms of legislation is the first law I've noted here, Chok Le'Esder Hidaynut B'Sichsuchei Mishpacha. I'll do full disclosure here. I was a very big opponent of this law. I think it's an irresponsible law. The title of the law means, or the heading of the law is, it's the law for arranging litigation in family conflicts. It came into effect, actually it was legislated in 2014, but it actually came into effect in July of 2016. What this law means is that today, if someone comes to me and says, I don't know, I have a conflict, and if in the past I would have decided that it's the right thing to do to file a lawsuit of some kind, אפשר לסובב את זה ככה? ככה? This one? ככה?
מה שזה ייפול?
כן. Okay, so what this law means is if in the past I would sit with a client and we would say they required some or other remedy in the court, in a family conflict specifically, I could make the decision that this is a good time and file a suit against the other side. Today, I'm not allowed to do that. Today, according to this law, what we have to do is put in a very simple one-page form. It's called a bakasha liyishuv sichsuch, which means it's a petition to resolve a conflict. The court then refers the couple to, or it could be a parent and a child also, it doesn't have to be a couple. The court then refers these parties to a court social worker. Often in the press, if any of you have read about this law, it's referred to as a mandatory mediation session. That is in fact incorrect. The mandate of the law is to some extent amorphous. It's supposed to, the meeting with the social worker is supposed to be to inform the parties what their options are for resolving their conflict. Be it mediation, be it negotiation, be it something called collaborative law, and be it litigation. And to some extent in the law itself, it specifies that the social workers are supposed to help the parties understand what the impact of these proceedings will be on their children, what the cost to children is of the divorce itself. Once that's filed, the parties are not allowed to file a suit to the court for 45 days. I'm not going to get into all of my criticisms of the law. I do, however, for those of you working in situations of abuse, particularly non-physical abuse, I think it's very difficult and detrimental to people who've been in a relationship where there are extreme power imbalances, and where one party or has experienced abuse of some kind or another, to be made to go through that process. I'm a big fan of mediation in the right situations. I'm a big fan of not litigating if not necessary, but I don't think that as a law we should have taken the decision-making power out of the hands of people and really slowed down the process. Because one of the things in many cases for a successful proceeding, particularly when we're talking about divorce, but any legal proceeding, is the pace it takes and is the time it takes. So it may take people years to reach a decision that they're leaving a particular relationship. It may take them a lot of deliberation, soul searching. It's not an easy decision. I always tell people it's like transition in childbirth. That period of time is the most difficult time. And then we're saying to them for 45 days, stop. Unfortunately, the social workers in the family court prior to the law were a very precious resource for us. They did a very, very good job. I did refer people to them for mediation, either of the whole conflict or of limited issues having to do with children in general. Today, they don't have the time to do that. So as a result of this law, I feel that not only is it not effective, and I wrote an article about it called John Lennon Meets the Emperor's New Clothes, which didn't win me a lot of friends in certain circles. But we've lost the resource that we had of really good social workers who do work with the courts. But what's important for you to know, and what's important for us to know in our work, what's happened as a result of that, is when people come to us today for an initial consultation, because I know that the process is really slowed down, because you have to wait 45 days before you can file anything, and then the person who's filed it has another 15 days to choose if they want to file either in the family court or the Rabbinical Court. What's happened now is that more or less when people come to us and they're considering some kind of proceeding, we right away say, you have to file this petition. Because if we need to go to court, we're going to have to start, the clock needs to start ticking right now, which is not always the best thing for this particular family in this dynamic. And I'll just bring a really absurd situation that we just had now. A couple was post-divorce, but they had issues that they were litigating. That litigation stopped about 6 months ago. Now there's a huge problem with one of the children, and we filed a lawsuit, and the other side came back and said, wait a minute, there's this new law here. You have to try and at least send this couple to the family court, social workers, which is really detrimental to the particular child in question. The law does provide for ways around it. There are emergency petitions that you can file. However, everyone in the field needs to be aware of this change, and you need to take it into consideration. Even at the point at which you might say to yourselves, well, when should I have this person talk to a lawyer? Because it may be that prior to this, things could have waited a little bit, but time is very precious always, and it's become more precious as a result of this. So it's something for you to keep in mind. Personally, we've kept our own informal survey of what's happened with the law, with people who've come to us in our office, and I would like to be wrong on this, but we haven't seen any really positive results, and because of the uncertainty it creates, we've seen actually negative results. And that there are sufficient resources out there that people who are going to mediate will find their way to a mediator, that people who just want to negotiate will be able to negotiate. And I always say I make a lot of money out of bad mediations, because people who shouldn't be in mediation waste a lot of time and energy, and they end up usually having really bitter, acrimonious litigation when the mediation hasn't worked, which is a shame for everyone involved. So perhaps okay. I know that abuse is a big issue for many of the people here, much of the work that you do, and you still have the domestic violence unit, I assume. So I want to talk about a couple of different laws. One is called, and terminology as well. One is called the Chok Leminiat Alimut B'Mishpacha, the law for the prevention of violence in the family, which is from 1991, which was a huge, huge development in Israeli law, which meant that the abuser was the one taken out of the home, and the abusee was not the one necessarily running to find shelter. Later on, there was a second law enacted, which is called Chok Leminiat Hatrada Ma'ayemet, which was really modeled on American laws, anti-stalking laws. So sometimes there's an overlap between the two of the laws, and sometimes the Chok Leminiat Hatrada Ma'ayemet, the non-harassment law, is relevant for non-family members as well. There's sometimes so I want to talk primarily about the Chok Leminiat Alimut B'Mishpacha, the one that relates specifically to family violence, which could be violence between spouses, violence between a parent and a child as well, although there is a different set of laws that deals with that as well, and violence from children. Often, I'm sure you've encountered cases where there's a problematic adolescent who's being violent towards a parent. So one of the ways of dealing with that can be, in certain circumstances, to file for this restraining order. The restraining order that's issued under the Chok Leminiat Alimut B'Mishpacha, the law for the prevention of violence in families, is referred to in the law and in common parlance as a tzav hagana. All right, I'm sure you've all heard that. Tzav Hagana, an order of protection. I'm going to leap ahead a little bit, or that's different from what the police issue. If you've had people who've filed complaints at the police about an act of violence, often the police will tell the suspect that they have to stay away from the other party for 5 days, for 14 days, sometimes for 30 days, but that's rare. That's called a tzav harchaka, all right? In order to keep distance. The two are important to know about. One does not replace the other, okay? The police do not issue an injunction that's to keep a spouse away from the other spouse. That the tzav harchaka is kind of allows the police to do some kind of investigation to see what's going on, but it's not it's not extended automatically. So if someone files a complaint and the police tell the spouse to stay away for X number of days, that's not sufficient. At that point, it's important for the person, if there was an incident of violence, and if they are actually afraid of the person coming back into the home, it's important to go to the family court or to the Rabbinical Court, which has parallel jurisdiction on this, but I'm going to talk about that in a minute. It's important to go and ask for an order of protection. Some of my colleagues abused this law, which meant that they were asking for orders of protection frivolously. There was a backlash a number of years ago, in my opinion, that the courts were not extremely, but more hesitant to give them than I always felt they should have been. I think things have reached a fairly reasonable place today. But bear in mind that it's an emergency order. It violates the very basic constitutional rights of the person being removed from the home. So there have to be grounds for it. And there have to be grounds for it close to the time that you're applying for the order of protection. Excuse me, sometimes I'll get people come and say, but 3 months ago, he hit me. You kind of missed the boat. You didn't miss the boat to file a police complaint. You can file a police complaint for a long time afterwards. But you missed the boat for going to the court and asking for an order of protection. Because it is such an extreme violation of someone's basic constitutional rights, the courts are very careful about this, and in my opinion, correctly so. Excuse me. So sometimes people want to think about it. You don't have a long time to think about it. Maybe that it's not right for that particular family. And that's the other thing that I do want to say. Even if all the conditions are there for asking for an order of protection, you always have to ask yourself, is this a good thing for my particular client? What do I mean by that? I once had a case. Someone came to me. It wasn't even a case. So someone who knew me asked me to help her. She was a young woman. She was quite pregnant, 7 or 8 months pregnant. I work a lot in family violence, or I worked a lot in family violence, less so today. I don't know what your experiences are. I rarely saw people who really had been beaten up very, very seriously, which I'm not downplaying the other acts. This woman was beaten up seriously, and the husband had thrown her down on the sidewalk while she was pregnant in front of people. It was really a very serious act of violence. The husband was arrested. The police weren't releasing him so quickly. But when we asked for the order of protection, the husband kept saying to her, I love you, I love you, I love you. She was very weak. She did not have a good support system. I asked the judge to intervene and not allow the person to speak to her that way. He overrode me, if there's such a word. And she ended up going back to him. So you have to know that the procedure for an order of protection is that you can ask for it, what's called an ex parte order, just with the person asking for it going to court, but there has to be a hearing within 7 days with both parties there. If the person, the particular person is not going to do well in that encounter, you need to think about if there are other ways to protect that person. Whether it's a shelter, whether it's a family member who can take them in, whether there's some other way of ensuring that that person is safe. Because time in all of these things is very important. And where a person is in terms of their ability to make really serious decisions and confront the other person and ask for the kind of help they need and recognize that they need that kind of help. So although an order of protection can be a very important step, it can also backfire. So like anything, you need to really ask, is this the thing that we need to do right now? Is this going to be ultimately helpful for my client? Unfortunately, there are also lawyers who are interested in scoring points. I got him this time, but if it's not good for your client, you haven't really done anything. The law was amended a number of years ago to allow for an order of protection in cases of emotional abuse. With all due respect to the judges, who I think are very good, they don't know how to apply it. They don't know how to recognize it. It's a very big problem across the system, not just with regard to orders of protection. It's a very big problem in dealing with a wide variety of issues. I've had cases of extreme emotional abuse where there is no physical abuse, and I'm sure that you've encountered these cases as well. I personally have never had a judge agree that this person needs an order of protection. I think it's a problem in the system, and I once was in a conference in the States and someone spoke about forms of abuse and emotional abuse, so I was all excited. I thought I had an answer to all my questions, and I went up to him and I said, you know, I have a big problem in Israel. The social workers don't always recognize it. The judges don't always recognize it. How can I help to explain things better for my clients? And he said, we have the same problem here. So I understood that there is a big problem. So if you encounter the law that says you can apply for an order of protection in cases of emotional abuse, know that it exists. Would I rush to do it? Not at all. Because the worst thing for particularly women, not always a woman, there are men who are in very abusive relationships, but the word, I'll just use woman just for the sake of making things easier. The worst thing is for someone who knows they've been abused to go and ask for an order of protection and be turned down. I cannot describe to you what this does. It undermines their sense of reality. The system that should have, or they wanted to validate them, has let them down enormously, and it can be a tremendous setback. So sometimes it's better to look for other more creative solutions than to run and get an order of protection. We have a particular problem today in Jerusalem because there's a shortage of judges. So it used to be, sometimes I'd say, okay, I've got a borderline order of protection here. If I knew who the judge was who was going to receive the order, because they take turns, I said, maybe I'll take a chance, because a good judge can use that hearing to get a lot of other things done and dealt with, to fast forward the process. Today that can't happen because in Jerusalem today there's a retired judge who was brought back to specifically deal with orders of protection. So her jurisdiction happens to be a she right now, and they did it because there's a shortage of judges, so I'm not being critical of the system per se, but she's only going to deal with that order of protection. She's not going to see the family when they have a larger, to deal with the larger set of litigation, so there's no real advantage of trying to put this couple in front of a judge and see if they can help the process along. The second law that I mentioned, which is really the anti-stalking, anti-harassment law, has to do in cases if someone's picking up the phone all the time, if someone obviously is following. Again, it's not exclusive to family situations. It also can be between neighbors and so on, but it is something to be aware of because sometimes something doesn't fit into the criteria of the law for the prevention of violence, and it does fit into the criteria for the anti-harassment law, and it may be useful and it may provide some degree of protection for your clients. Again, the most important takeaway here is to always be aware that if the police have said that someone issued a restraining order for a particular period of time, it's not automatically renewed, and you must, if their person is in danger, they must go to the family court. The orders of protection by law are up to a period of 3 months. They can be renewed again for 6 months, and in very, very rare cases, they can be issued for up to a year. In many cases, judges don't even issue it for 3 months. They have total discretion here. In other words, they could say, okay, I'm saying this person's, this was an off event, there's not a pattern of abuse here, everybody needs to calm down, everybody needs to figure out what they want to do with their lives. I'm going to give it for a month. If there's a problem, come back to me. If there's not a problem, that's great. They also have the ability to refer to therapy within the framework of the law. They don't do it very often. And they also have the ability to say, okay, I'm going to give you, if you're violent again, or you have to give someone kind of a financial guarantee that you won't be violent again, and they can sometimes do that. And it really, as you know from your studies, I'm sure, and experience, there are different topologies of family violence. So the judges sort of want to guess about what kind of person they have in front of them and make their decisions based on that. Okay. I want to touch a little bit on the difference between the family courts and the rabbinical courts. There have been many changes in this area as well in the last number of years. First of all, I want to dispel a myth. It's not an issue of one's good for women and one's good for men. Let's get that off the table right now. And a few years ago I would have said the following: when does it make a difference about where you're filing your cases, to the rabbinical court or to the family court? And in general, I would say I don't rush to file in one place or another, because first of all, I think that some lawyers do that when their clients aren't ready for litigation, which is a very big problem. Where would I be more cautious? I would be more cautious where there is a real difference in lifestyle between the two parties and there are children involved. Because in the rabbinical court, issues, and I'm not making a valid judgment, it may be right, it may not be right, but for the client it might not be the right thing. They're going to generally prefer, when there are children involved and issues of children are being adjudicated in the rabbinical court, they're going to prefer the parent who has the more observant lifestyle. And by that I mean, even if it's a toss-up between a child going to a Beis Yaakov or going to the Mamad school. All right, everybody knows what I'm talking about? Okay. So there, that's an important question to ask a client when they come in. Is there a difference in your lifestyle, in your approach to your lifestyle? Because and depending on who the client is, that can have an impact on where you choose to adjudicate this particular conflict. At the end of the day, or the beginning of the day, both the family courts and the Beit Din will refer to social services to get a report. But at the end of the day, the decision is with the judge, and the decision is with the Dayanim in the Beit Din. Having said that, I don't want anyone to get the impression that the family court will automatically rule in favor of, as it were, the less observant parent. That's not the case at all. And we've certainly had cases where someone comes from a Ger Hasidic background, for example. One party decides they don't want to be observant at all, usually. And the judge rules that the judge in the family court rules that the child has to stay in the Hasidic school, whatever it is, because that's his or her determination that that's what's in the best interest of the children. Sometimes we'll have people coming to us in that situation and say, I'm going to go to the court because then they'll let me put the kid in the school that I want. And it's very important for them to understand that that's not the case at all. So one of the features of Israeli law, Israeli family law, which is sometimes difficult for people coming to from America or Canada to understand, is that the whole issue of custody is different in Israel as opposed to the United States. In Israel, since the 60s, we have a law that talks about apotropsut, which means that both parents are absolutely equal with regard to issues of education, place of residence, medical issues, and religious issues on the level of you certainly can't convert a child to a different religion just because one parent allows. In many ways, some Western countries are more similar to Israel today, but it's not a function of custody. So today in Israel, when they talk about custody, it's really a very ill-defined term. The truth is, in my practice, certainly when I'm doing agreements, I often don't use the word custody, which is the trend in some proposed legislation as well. I talk about achrayut horit because it's not such a meaningful term. For some people it's a very loaded term, and therefore I like to get it off the table. By the same token, I once had a case where the dad was really the primary caretaker, but for the mother, it was really important that she have custody. So I got my client to agree, I got the social workers to agree, and we said she had custody. It didn't really make a difference, because what's important is how the week's divided up, how the time is divided up. So there's a great deal of talk now in Israel, and this is one of the developments over the years of shared custody, mishmarat mishutefet. And that has also come into the Beit Din, as well as the family court. So on the substantive issues, putting aside the example I spoke about before, you're not going to find a tremendous amount of difference between the family court and between the Beit Din. Although recently the Beit Din came out with a statement, but I think it was for more PR than the substance of certainly what I see in the Beit Din here in Jerusalem, which by the way is quite good. I don't think it was such a substantive issue.
Statement that what?
They said, oh, I know, there's a lot of discussion, some really because of pressure from men's groups over the last number of years of canceling what's called in Hebrew chazkat hagil harach, which in English is called the tender years presumption. So in the law, it actually says that children under the age of 6 should be in the mother's custody, unless there are mitigating circumstances. So the fathers groups made a big deal out of this. Just very populistic in my humble opinion, because the truth is, I don't really think the courts ever really ordered things, ruled on that basis, except in some very rare exceptions. I think certainly the time that I've been practicing law, which is about 20 years, courts made substantive decisions. And even when I had a case when I worked in women's shelters and a woman was with her baby in the shelter and asked for a temporary custody order, a baby, and we argued there's a tender years presumption, the judge said, no, I want to find out what's the best thing for this particular child. So there's legislation in front of the Knesset for a long time to do away with it. In my humble opinion, there's very little practical ramifications to it, and it's a very loaded political issue. Does that? Yeah, okay. So anyway, their statement was, no, with us, the tender years presumption is still relevant, which is not the case, because it's just not the case. It's not the case. They may have a preference for mothers with young babies, but in other cases, they're going to do like everyone else. Okay. Now that I know I'm being taped and everything, where am I critical of the Beit Din? I'm critical sometimes in procedural issues. For example, if I go, and I kind of alluded to it very mildly, I said the Rabbinical Court has parallel jurisdiction about orders of protection. I filed there in the summer in a case because everything else having to do with the case was in the Rabbinical Court. I needed an order of protection. It was the court recess, so it didn't go to one of the dayanim who regularly deal with the case. It went to a roster judge, and he did not deal with it. He actually said, sent it to the response of the other side within 15 days, which is obviously, and it's an inherent contradiction in terms when you're dealing with an emergency order. So that's my criticism sometimes of dealing with the Beit Din, is that they're just not always so up on the procedure. Again, it's not everyone, and in general, there's a tremendous improvement, even in that area, in the Beit Din today. The other area, which is in a state of flux, has to do with child support. In the past, generally, it's also very politicized, and also as a result of a lot of pressure from men's groups. There's been a lot of pressure to change the law about child support, which I'm not going to get into right now. It's a little bit complicated and totally unclear. So for various reasons, it used to be preferable to go to the family court to get orders of child support, and also, in my legal opinion, which is also being disputed today, the family court had exclusive jurisdiction over this unless the parents both agreed that the Beit Din would deal with it. Today, there was in the summer, there was a Supreme Court ruling about child support, which has effectively reduced the awards that are being given by the family court. The Beit Din now is saying, look, come to us, we're going to look after mothers and children better. I hope that'll happen, because I think that as a result of this recent Supreme Court decision, I think it's going to be bad for children and mothers. Anyway, I'm not going to get into that right now. So, the takeaway here is that if people get pressed, he's going to run to the Beit Din, it's going to be better for him because he's a man. She's going to run to the family court, it's going to be better for her because she's a female. The answer is, in very broad terms, no. There may be advantages to each of those particular bodies, and there may be disadvantages. And you have to weigh and understand what's at stake in each of this. In some cases, the worst thing to do for the particular individual sitting opposite you is to say you have to run to any court or to a Beit Din because they're not ready for it. And, yeah.
What's the definition of ready?
Okay, so the question is, what's the definition of ready? Which is a good question. It's a very good question. And there are two sort of milestones, I think, you have to say. First of all, are they ready to make a decision that they're going to court, whatever that means? And that could have to do with, you sense they're really ambivalent about this. Some people will say to me, no, if I file, I know he's going to come back to me crawling on all four. Right? So I know that person is not ready because they have to be prepared for the other option. Because it usually doesn't work out like that. It's an aggressive move, it's perceived as an aggressive move, and you have to be prepared for all of the fallout from that. It might be you get what you want there, but it might be you don't get what you want there. So that's a person who's not ready. If they have unrealistic expectations about what the process is going to bring. Other people who aren't ready, who they're not lined up for it yet. They don't have a support system. They don't have a way of supporting themselves. Because when a woman in particular, or unless she's making a good living, initiates proceedings, she's got a cushion period where I always say, make sure there's some kind of backup here financially. Because you don't know how things are going to play out, and until things fall into place a little bit, you're financially very uncertain. So that may be a circumstance. It may be your sense that emotionally they're not ready to take that stand. So it can be a number of factors, but we've all been wrong on this, but it's a good question to really ask. The other interesting thing, since you asked about being ready, there's a colleague of mine in the city, and we do a lot of work together, and we managed to reach agreements together, and she likes to push things through, and she said, okay, we'll do this, and then they can get divorced. And in that particular case, it was my client who wanted the divorce, but she wasn't ready to be divorced yet. Which is an interesting phenomenon, and the first time it happens, my reaction was, oh. And but it's actually something you have to take into account. All right? And it took another month, didn't take for forever. If someone's taking a year for it, then you've got to ask some questions. But it may be they need another month, they need another 2 months. They're just not ready to cross that particular bridge right now. So sometimes even if you've agreed on all the substantive issues, you need to take a step back and say, is this good for this person right now? Yes?
I've encountered sometimes clients where the woman is contemplating start divorce proceedings, where she says going to the Beit Din Rabbani is not an option because the impression is that the woman who initiates that proceedings, she quote unquote gets nothing, she loses everything.
Okay.
And I was wondering what.
Okay, so that's a good question, and thank you. The question is, sometimes there are clients female who think that if they go to the Beit Din Rabbani, they're going to lose everything? Yes. Okay, so as I said before, in general, I don't think that there's a gender bias in either direction, either in the family court or in the Beit Din Rabbani. Where is there a problem, perhaps, what she might be thinking? She may be thinking of the halacha category of a moredet. If she initiates proceedings, and there aren't halachic grounds for proceedings, right? She doesn't have halachic grounds to leave the house or to ask for divorce, she might therefore lose something because she's a moredet. The truth is, in my humble opinion, it's not such a complicated question, in my opinion, what a moredet halachically can lose are the right to spousal support, mizonot isha, and perhaps the right to her ketubah. And yes, the right to her ketubah. Mizonot isha today is an issue in very few cases. Mizonot isha, spousal support is relevant where a woman doesn't make her own money. It may be if a husband was making 50,000 shekels a month and she was making 5,000 shekels a month, she would still be eligible for mizonot isha. But certainly in Jerusalem, we're dealing in general with a very poor population, or poor in relation to other areas of the country. And it's, if a woman is making 5,000 or 6,000 shekels a month, no one is going to award her mizonot isha. So that's one issue. The second issue is the ketubah. But then you have to ask the question, when I started practicing the Batei Din, we did not award ketubah money that often. It's become more and more common over the last decade. So just a cautionary word, all those inflated ketubot that you hear about or someone in your family wants to do, don't. But, and then that's the question, because she's always going to have to confront that question. So does she want to stay in the marriage and wait till he sues her?
Where there is a lot of grounds for the marriage to end, where the husband's problematic in
Yeah.
different areas. I've heard that the woman says, well, the Rabbanim will start and say, shalom bayit, shalom bayit.
Okay, so that's also old-fashioned. That's not happening so much today. I'm sorry. Okay, the question was, there's another rumor out there that the Dayanim will, when a couple comes in, they'll say shalom bayit, shalom bayit. My experience is that is just not the case. I did have one case where it was a young couple from a very religious background, and the truth is it was a good process because my client didn't really want to get divorced, so they sent him to counseling for 6 months. When that didn't work, they said, okay, now you can get divorced. But in general, the people that I take to the Beit Din, they accept it. What they will do, and this is important for you to know, is they'll often say, let's say one party wants to get divorced, the other party doesn't want divorce. They'll say, okay, we have our counselors, therapists we work with and we trust. We want to send you to X person and hear if they say there's a chance for this marriage or not. The reason they do that is not for shalom bayis per se, if it works, if that happens, but it's to get an opinion, is the marriage salvageable or not? Not to look for halachic grounds, just to see, can these people is there a possibility for these people to live together? Once they get that opinion, they obviously can't force the recalcitrant spouse to give or accept the get, but it gives them a certain amount of leverage. So I always tell my clients, go to that meeting, even if you don't want to sit in the room with them. And I had an extreme case of extreme violence where they sat separately, and let's get that opinion, because it will help the dayanim to expedite the process. So if you hear of such a thing and your client says, should I go or shouldn't I go, it's not for shalom bayis in general. Okay? Yeah.
What about asset distribution aside from the ketubah? Especially if significant assets exist.
Okay. So the question was, what about asset distribution aside from the ketubah in the Beit Din as opposed to the family court? So the first thing you have to know is there's no what's called double dipping. What the dayanim will rule is that you might be entitled to ketubah, and it might be worth, 100,000 shekels, but we're not going to rule on that until we see what you're going to get as a part of the asset distribution. Because you can't get, 500,000 shekels of the other party's pension rights and ketubah. Okay? If there's nothing else there, then you may get the ketubah. If there's only 50,000 there, you might get another 50,000. But you don't get double. The practical question of asset distribution, there are some very good dayanim, but it has to do with the procedural issues. When I have a complicated property case, I generally do not like to go to the Beit Din. If I have, simple, there's an apartment, there's someone worked as an employee, they're clearly know what it is, then I don't have a problem doing that. The substantive law, in many cases, and more, particularly with the younger generation of dayanim, is very similar to the family court. The last sort of major difference is that the Supreme Court developed this doctrine, which might be good, might be bad, but it's a doctrine and it's out there since the early 2000s, that if someone came into the marriage with an apartment, the parties lived in that apartment, the parties paid the mortgage together, the parties raised their kids there. When the marriage breaks up, there's a very good chance that the spouse who didn't own the apartment will get a big chunk of that apartment. That's less so in the Beit Din. Because in halakha, the actual registration and payment for properties is just much stronger than it is in family court. Although there were cases, like I just described to you, that went to the Supreme Court, and the Supreme Court said that the Beit Din has to rule according to the Supreme Court's ruling on this issue, but it doesn't always happen.
One follow-up question. I was a divorce lawyer in America. So I had an issue where, because the husband kept most of the assets in his own name, the Beis Din didn't want to distribute them to the wife. Is that an issue here as well?
Okay, so the question is that in America in the Beis Din, because the assets were in the husband's name, the Beis Din didn't want to distribute them to the wife. So that is really, as far as I understand it, the halachic position, and that really happens because you were dealing with the Beis Din in America. There was a time when the Beis Din here did that as well, with what's called Chok Yachasei Mamon, which was legislated, the law that determines financial relations between spouses in 1973. There's a clause there that says explicitly the Beit Din has to rule according to that law. For other couples married before 1973, they were not necessarily dividing assets that way, and that was when the issue of moredet became important for property issues. There was a Supreme Court decision, I think in the 90s, that overturned that. Again, for the most part, except in the case that I mentioned where there was a really were assets from before the marriage, the Beit Din will tend not to divide those up, which I actually think in general is good. But the family court very often will divide those assets up. Okay, is that clear? Yeah. All right. The other. I mentioned, alluded to the issue of violence against children or by children, and there's something called Chok Noar. There's a law which deals with children at risk. I'm going to relate to it, to go back to the orders of protection, the Tzavei Hagana that I started with. Sometimes you'll have a violent adolescent or an adolescent who's wreaking havoc in the home and abusing other children in the home, and you can't get social services involved. They're overworked and underpaid. I think they do a good job in general, but they're really overworked and underpaid. You can't get them involved. You don't want to go to the police, and sometimes what I'll say is, let's go to court and ask for an order of protection. Because then it forces the system to find some kind of a solution. The judge may say, I want the social worker here tomorrow morning at 10 o'clock. I want somebody to be dealing with this child. So, first of all, sometimes the family just needs protection. And there's an auntie the kid can go to, or grandparents, or a friend, I don't know. But sometimes it's a way to force the system to act here. Because I'm sure that anyone here who's dealt with children at risk has been frustrated at times by the inability to get the system involved. Am I right on that? Okay. And again, there aren't enough resources, and they're not a powerful lobby, so no one's giving them more resources. So sometimes the act of going to court can, not always, help fast forward the process. Chok Noar allows social services to intervene when there's a child at risk. They have a variety of options available to them. Generally, they will try to work together with the family members and with the child, depending on his or her age, and try to reach agreements about where the child should be placed, if the child should be placed. Should the child have a full day program until 7 o'clock, so he or she is out of the home? They have a variety of options. So again, they generally try and have what's called a vadat hachata, a decision-making committee, and to get everybody on board, because the feeling is if everybody's on board, it'll be better for this child. That may be right, it may be wrong, it may be that in 80% of the cases it is better for the child if the parents are on board, but one of my criticisms of the system in general, not just with regard to children at risk, is that there's a trend, and I'll go back to the new law we talked about where you're not allowed to go to court for 45 days after you file this petition to resolve a conflict, is the failure to identify and effectively name that sometimes one party is more problematic than the other. And the system doesn't want to do that. I think part of it is a issue of resources, part of it is ideological, which is, as I said, if we get everybody on board, whether it's parents who have children and they're getting divorced, or whether it's a child at risk, it'll be better for the kids. And sometimes that's just not the case. Because I've had kids at risk when the parents are divorced or separated, and there's one parent who is blocking every single move to get the child the help he or she needs, which is incredibly destructive. I once had a kid who actually never got the help he needed because I got involved when he was 16. By the time he was 18, still nothing had happened, and there was no reason to help him. And I had a hearing in the juvenile court, which deals with this, as opposed to the family court, although family court can also deal with it. But and as we walked out, the lawyer who was preventing for the problematic parent, who was actually preventing the child getting what he needed, said, "This isn't personal. This is just how we do our job." And I said, it's not how I do my job. So, why am I saying this? Because sometimes my clients say if we don't reach an agreement, we're going to have to go to court. To which I say, bring it on. Best thing, I want to get the judges in the juvenile court today are also very good. I want to get the problematic parent in front of the judge. I want to get solutions for your kid. So often social services will spend a lot of time, and in my opinion, sometimes too much trying to bring both parents around, where, to my mind, a better solution is get them in front of the court. And which means also that sometimes people are afraid of court, so you need to calm them down and say, no, it's not like in the movies or something, and no one's going to take away your kids. This isn't Dickens. It's not even the United States of America, and it's okay. You should go to court. And sometimes also in the committees, they'll want the parents to bring the problematic parent to an agreement. The parent who wants the kids to get the proper treatment is asked to make concessions, which might not be good for the child. So they should know that going to court is not a terrible thing and may actually be very, very helpful. Which leads me to, yes?
Doesn't the law require, though, that the social services attempt to involve both parents before they turn to
Yes, but the question is, doesn't the law mandate that the social services involve both parents? And that is absolutely the law. It's part of the guardianship, the apotropsut of both parents. You can't do anything without the agreement of both parents unless you get a court order to do so.
Will the court agree that to bring one parent in to go against their will unless the social services has attempted at first to
Yeah, they want us to know that so the question is, will the court immediately hear the case before there's been an attempt to bring both parents in? Is that correct? Unless there's an extreme case where we know parents, like a drug addict sitting in the gutter, they will try to do that. They will attempt to do that, and the courts want to know they do that. My criticism is, how long do you give that? How long do you give that process, and at what cost to the child? Yes.
How would that apply to married parents who one wants the child to get help, another one, which is, how would that law apply?
Okay, so the question is, how would the law apply to the married parents where one parent wants one thing for the kid and another parent doesn't? The same as it would apply to separated parents. They would try and bring both parents in, they would try and bring them both to an agreement, they would expend energy on that. Probably they would expend even more energy because they understand that it's good for the child also, hopefully, unless it's a totally dysfunctional family system, that the marriage stay intact. And if necessary, they'll have to go to court. So it's not a function of are they married or not married. It's a function of what, to some extent, I think that when parents are divorced, kids get less of the help that they need because the system, again, says these are children of divorce, the parents need to deal with their conflict and then the kid will be okay. And that's not always the case. So I think there's a certain stigmatizing really of the parents, which they may have created some of the problems, but the real issue is not that the parents are, that there's a high conflict divorce. The issue is something else. And I think that sometimes there's a failure to identify that as well. Yes?
Sorry, I might have answered it. If a couple is divorced,
Yes.
and one of the parents want to send their child to some kind of therapy or, they need the agreement of both parents.
Right.
And is that true when there's things going on in the home? Let's say one parent doesn't want them to have an iPhone and the other parent does. I'm saying like the groups are very...
Okay, so the question was, we know that if one parent wants one thing for a child and the other parent doesn't, then they'll have to both agree or go to court. The court, and the question was, what about if one parent wants an iPhone, one parent doesn't want an iPhone, or something along those lines. Courts traditionally, and in a healthy way, don't want to get into the kishkas of a family, all right? And they shouldn't. The question becomes, in the cases that I deal with, if a kid is in a school where the parents are separated or divorced, and a child's in a school where they have to sign off that they won't have an iPhone, but one of the parents actually has an iPhone, how does that play out? How does that play out? Which is, because in general, nobody wants to get into high resolution about what's going on. Everybody lives their life the way they live their life, and that's the way it should be. But what happens when it spills over into a different area? And I have a case like this right now, which is problematic in my opinion. Does that help or not help?
But I'm saying there's no bottom line as far as you're concerned.
The bottom line is always, it's very general, what's the best interest of the children? Tovat HaYeladim, which is a very wonderful thing. I think it's gone through different permutations, and I think that in the system that I work in, the family court, there's a reluctance of judges to take their own decisions about what's Tovat HaYeladim without outsourcing it to social workers or psychologists. So I wouldn't like to see someone ask for a social worker's report about should there be an iPhone in the house or not have an iPhone in the house. There's a point at which recently, a client of mine asked me, what should we do about if my whatever wants whatever? I don't want to, nothing big. And I basically wanted to say, if you can't figure that out without calling me, I'm not sure you should be a parent. Really. There are things that, and people are afraid. People are in proceedings, they're afraid. But there's a point at which the system should not be involved with that degree of high resolution on the things going on. Again, there are the extreme cases where you got a kid in a school where they're not supposed to have internet, and there is internet in one of the homes. That may be a different issue. Okay? It's a little, yeah.
What's the watch over the social workers? Like, are their qualifications checked out, or? Like, sometimes you think that they have no idea what they're doing.
All right, so the question is, who's watching the watchdogs? Is that the question? Who's watching the social workers and what are their qualifications? Okay. Again, I think they're generally good.
There's a special course for
Yes, I'm good. Yeah, they're different. They have to not only have their BSW. If someone's what's called, it used to be called Pkidat Sad, it's today called an Ovedet Sozialit L'Sidrei Din, who gives recommendations about custody and visitation. They have to have a special course. If they're working with youth at risk, they have to have a special course, and there is a level of supervision. Having said that, they make mistakes. They do make mistakes. And I have several fundamental disagreements today with many people in social services, although I think it's very important to work with them effectively and not just criticize them, because they get criticized sometimes unnecessarily. Having said that, I have on occasion actually filed reports, complaints to the supervisors. And they always send me letters that their underlings acted perfectly according to the best of their professional abilities, etc., etc. But I know that it's in their records. And I know that the next time they're going to watch their step. So I don't flood people, and I also compliment people when they do something. I actually have a case now in the South where they did something they should not have done, and I sent a letter to the supervisor, who then called me, very nicely actually. She said, I want to know how I can help here. They turned around, not because of me, but because they understood there was a problem here, and I have a very good working relationship with them. So it's important to not file complaints every day, but every once in a while I do, when I think they've overstepped. And really, I had a case where, there was a young woman involved in something, and the social worker asked the Rav Ha'ir for his opinion, which, yeah, they heard from me. The local rabbi. I mean, he had an official position, but it was not appropriate. So I think that there is supervision. I think, again, they're very overworked and very underpaid. I think the courts have outsourced far too many issues to them because of this issue of Tovat Yeledim. And I once had a really simple case of a name change for a woman who had a child, and there was no connection with the father. She'd remarried, they were living in a Haredi community, she wanted everybody to have the same last name. They sent it to a social worker for a report. I said, seriously? and she was petrified that they were going to contact the biological father. And I said to the judge, I'm just going to withdraw the case here. So finally everybody woke up. But the courts outsource far too many decisions to the social services. Part of that is I can blame my colleagues, because then they appeal and say, you didn't get a social worker's report. How do we really know this is Tovat Yeled? So they work hard. Their goal, and if I'll just, since I already said why I'm critical, that I am, I'm going to explain why. Because I think this issue of bringing my mantra these days is the equality is killing us. When you have a set of parents, and just using our common sense, we can figure out that one is really more problematic than the other. I don't want to get reports that say both parents need two. But that's the mantra across the system. And a judge, not in Jerusalem, recently she said, I'm sick of this joint custody business. The social workers take the most difficult cases, make their lives easier, and just recommend joint custody, and then they don't have to make a determination. And there's a great deal of truth in that. So nobody wants to point a finger, and nobody wants to call a spade, and in my humble opinion, children are suffering as a result of that. So that's my al regel achad criticism of the system today. Yes?
Is there a point at which, in the case of divorce, if they're looking for therapy for a child, and let's say the father is mostly in America or and comes back every so often and is trying to stop it, is there a point at which he's considered abdicating his?
Okay, that's a very good question. The question is, let's say a child needs therapy, the parents are divorced, one parent is not here all the time abroad, or just abdicated his parental responsibility and is here. And that depends, then what happens. So first of all, when I'm writing an agreement, if I can get it, if I can get the other side to agree, I have a case now where I think that's going to happen, and I already wrote a clause in there that if he's out of the country for X number of time, then the mother has rights.
There are many lawyers not on your level.
Okay, it's a good thing for you to mention. If you can get an agreement, the other side sometimes won't agree because they'll see that as their parenthood is being maligned or something like that. The real answer is you've got a problem, and it's a big problem. It's a very big problem. I had a case where we had a psychiatrist report that the social services paid for because they knew the father was so problematic, that said the father shouldn't see the child. The girl didn't see the child from a relatively young age. When she was 16 or 17, she was going on a school trip to Poland. I had to I went to the court to ask for a court order that the Ministry of Interior should issue the passport with only the mother's signature. The judge, who is really not a good judge, not in Jerusalem, asked for his response. And my client had to agree that there would be an injunction against her leaving the country until the kid came back from the trip to Poland. Now, in my mind, that's just crazy. But that's the law, and the courts are rather reluctant to limit the parenting role in a legal way of the other parent. I do have a case in the Beit Din, actually, where the dad was saying no, no, no to everything, to therapy and medical stuff, and the Beit Din actually gave a decision that said the mom gets to make all the decisions. But it's a very big issue. It's a very big problem.
Just the second part to that is, what are the ramifications if what the mother does take against?
Okay, so the question is, what are the ramifications if a mother does take a child to therapy without the other, or father, one parent takes a child to therapy without the other parent's agreement? The truth is, it's an ethical violation for the therapist, and if the other parent is particularly aggressive, they can file a complaint with the Ministry of Health about this. It used to be when I started, things were, people took kids for therapy and didn't always ask permission. Today, very few people will, and really, in the strict letter of the law, you need to get a court order. You need to get a court order. It's a problem. It's a very big problem. Yes?
So would you suggest, if a psychologist or social worker is seeing a child, that the very first time they ask for a signature from both parents that this is okay?
So the question is, the first time you see, should you ask for a signature? I know that the Family Institute for a number of years has been very strict about this. Very, very strict about this. And the short answer is yes. Short answer is yes. Your license could be at risk, and it's just, you have to watch yourself. It may be, if someone's abroad and you can't be reached and you tried, then you would have something to say. But particularly if you've got someone who's going to be very nasty. There are people who don't show up for their kids' birthdays, but they show up when there's a chance to take somebody to court. So you need to be aware of those things. Okay? This takes us into the whole issue of what's called chovat divuch. When you, and this is something that you encounter in your work, which is the issue of needing to report to either police or social services when you see a child at risk, or that you think they have a child at risk. And here I've actually, I've referred to the relevant, in fact, I gave you actually the relevant ones. Okay. So, first, does everyone have these printouts from Chok Shin, which is the criminal code, criminal law in Israel. So first of all, section 322 and 323 set up the obligation, all right? Which that if someone has a responsibility, and you'll note that it doesn't actually say a parent, they're responsible for a child. They can't just walk away for it, whether it's from a responsibility as a result of law, as a result of a contract, or anything else that makes this person responsible. They have to provide basic needs for the child and look after his welfare, etc., etc. All right. Which is interesting because some people, I'll take this to a different context, sometimes someone will say, I didn't have to pay child support because there was no court order. Wrong. You have a child, you have a responsibility to look after that child, and that's actually in here and in a different law as well, in my opinion. Okay. All right. For your purposes, I want to look at a couple of other things. And it's a criminal offense to not look after these things. All right. So there are a couple of things I wanted to point out to you, and there's extra criminal responsibility for certain kinds of offenses against a child. 354 is important for you to know because it extends the statute of limitations for suspected sexual offenses, which only begin to start then from the age of 28 rather than from the age of 18. Yeah. Okay? So if someone comes to you and they said something happened to me when I was 14 and they're 26, then they can still file a criminal complaint. What I want to talk about a little bit is 368, which is your chovat divorch, okay, which is your obligation as therapists, okay, to your reporting obligations. So the 368 Dalet, which is on page 81 of 121, it says if you have a reasonable assumption to think that recently there was an offense to a minor or some person who is in some way what's defined as chasal yesha, helpless, which could be a person who's old, which could be a person who's in some way disabled, by the person who is responsible for him, okay, which we saw in that earlier clause, you have a responsibility to report either to a social worker or to the police. Okay? This gives, the next clause, 368 Daled Bet, gives the list of all the people who have this responsibility, which is anybody in education, a social worker, anybody who works for social services, a police, a psychologist, a criminologist, anybody who is involved in any paramedical field, or anyone who's a manager of a daycare center, or any place a child or anybody who's somehow needs protection is. Anybody who finds out about these things, you have to make the report. Okay? So there are two things here. One is 368 Daled Aleph refers to if I see my neighbor, or I think my neighbor did something to a minor, I have a responsibility as a citizen of the state of Israel to make a report, and the other is this specific list of professionals. Okay? 368 Daled Gimel is a tricky one, because basically, if I translate the substance of it, it means if one parent knows or has a reasonable assumption that the other parent has in some way damaged or abused the child, they have a responsibility to report as well. Okay. Okay, we'll get to that in a minute. So have you had discussions of this in your courses, in your work? Has it come up? Okay. So, yeah? Yeah. Yes? Okay. All right. So perhaps then, rather than me talking about it, maybe are there specific questions or issues? I do have something I want to say about it, but first I'd like to address any of your concerns relating to this. Yes?
What qualifies hitalelut gufanit? What about just spanking?
So that's a very good question. The question is, what qualifies as hitalelut gufanit? Does that qualify as spanking? That's a very good question. And I'll tell you where it's a very good question is when it comes up with the obligation between parents. Sometimes I'll have people who are afraid because they'll say to report that a parent was violent and in some way or anywhere along the spectrum, and because they've been frightened that if they do that, they're going to get in trouble for all the times they didn't report it. So, but to the substance of your question, there was a Supreme Court decision that said spanking is actually not allowed. Okay? You know, the answer is, it's the social services and certainly the police will treat it as circumstantial. They'll look at it from a circumstantial way, but in pure theory, yes.
Hitting your child is hitalut gufanit legally?
Yes, absolutely. Absolutely. You are not allowed in the state of Israel to use any kind of corporal punishment. Okay. So, and I just read an article about this. If anyone's interested, there was an article last week in the Atlantic on spanking. So, any of you grew up in spanking eras, you can take a look at it. Yes?
I was seeing a client, and I know we're required to report if we feel like one of our clients are in danger.
Mm-hmm.
And the client was in a situation where her children were terribly abusive.
Mm-hmm.
They were threatening to kill her all the time. And I said, can I please have the number of the Shkat Ravacha that you're working with so I can talk? And she said no, because she was worried about her children. Like she felt like it was her obligation to protect her kids, even though they could literally physically harm her. What were this? They were teenagers.
Okay.
17.
So it's a very good,
I didn't know
yeah.
it. Am I supposed to go even without her permission, or because she said I don't want you to go? Like what?
Okay. So the question is, what happens when there are a bunch of kids in the house who are being abusive to the parent, but the parent doesn't want to go to social services? Do you then have an obligation to go to social services? So I think there are two parts to that question. One is that, I don't know, are the kids at risk? Without knowing the situation, I think those children are at risk. Whether that imposes an obligation on you or not is a different question. And a strict letter of the law, I don't know if like a 7-year-old is hitting me, and it doesn't really matter. You obviously don't have to go. The question here is there a risk to the children as a result of their own behavior? Okay, that's one question. The other question is, and there's times you're not allowed to ask this question, but the other question is, what does it do to your therapeutic relationship with her? Because you're in a gray zone right now, so should you err on the side of caution or not err on the side of caution, and what's that going to do? Which is always a question, which may have to do with how you, I'm happy you raise this because it leads to the question of not just who are you treating and what are your obligations. So once a woman came to me many years ago and told me, I think the dad was very violent to the kids. Or the kids were between themselves. It was a long time ago, and she wanted to get an order of protection. And I said, if you go in for, I don't have a reporting obligation, by the way. Lawyers don't have a reporting obligation, except in very, very extreme cases. And
whatever. I said to her, if you take this in front of a court, you can be so sure social services are going to be in your house in the afternoon. And she didn't want to do that. So again, I think that the real question here is, are the children at risk from their own behavior?
Well, they would be sent to an institution. And
Okay, so first of all, let me dispel this, and that's what I said. We're not Dickens, and we're not even the United States of America. As a friend of mine who's a psychologist says, I don't think they send the kids fast enough. Which is not always the case. It was a joke. But nobody sends to institutions that quickly, from my experience. I mean, I have a case now where kids been wandering the streets for far too many months, in my humble opinion. And again, they were trying to bring the parents to agreement. It took a long time. Now he's fine this summer, but why? Well, you know, it took months. So people do have that, and people have that fear that that's what's going to happen. And I think one of our jobs, everybody working in this field, is to say, unless it's really extreme, you know, that's not going to happen so fast. And they're going, the stated goal of social services is to try and keep kids in the home or in the community, or both. Yes?
I mean, this is just, and I mean, a lot of the work that you have to do anyway is to reframe it so that it's what's best for the child. It's not about only taking the kid out, but it's about helping them have a better quality of life, blah, blah, blah,
Right.
and talking to the parent.
Right. So the comment here is that often when you're working, it's to reframe it and to explain that what's best for the child may not be what's right in front of them. But the question here is a legal question, and I really don't know the answer, and it would depend on what level of risk there is to the child or the children from this ongoing behavior. I would say if they're at any, I've told people to call the police. And certainly if there's anything like a knife involved or anything that can really cause damage, I say to call the police, because, and it's an extreme measure, but often it actually helps turn the kid's life around. Yes?
If there's a suspicion by the parent that another family member has done something to a child in the past,
Yes.
and the family member lives overseas,
Yeah.
and I'm told about this,
Yeah.
what's my
Wait.
obligation?
Let me just get this. So the question is, you're the therapist, someone tells your client,
Now, the client tells me
the client tells you
that there's a suspicion that someone in her family abused one of her kids.
that there's a suspicion that someone in the family abused one of the kids. Do you have an obligation? A few years ago.
And that individual lives out
And that individual is out of the country.
of visits.
I don't think so. I don't think so, but let me just but visits,
This person that was supposedly abused a child does visit. That child is already out of the house, but there are other children in the house.
Evanti. I do not, there are other children in the house? It may be that if that person comes to the country, you do have an obligation, yes. Yes, okay, we'll double check it, but it seems to me that yes. Yes,
Back to the spanking issue.
Yeah.
What do you feel about when Rebbes use spanking as punishments?
The question is, what do I feel about when Rebbes use punishment? That's not what I'm standing here today to do. But do I think parents have a right to object, maybe even an obligation? Yes. Yes.
In a case of a sexual abuse
Yes.
of a minor child, like a small, like
Yeah.
under 5,
Yeah.
if the therapist has a suspicion
Yeah.
from some of the play therapy
Mm-hmm.
that there's something going on, and the parent, let's say it's a father,
Mm-hmm.
or the child, the parents are divorced,
Right.
and the child spends Shabbos with the
Yeah.
father's family, and there's boys
Mm-hmm.
from the other marriage
Mhm.
there.
Mm-hmm.
How sure does a therapist needs to be about the suspicion?
Okay, I'm happy you asked that question, because the question is, if a therapist, it's part of the play therapy, has the sense from his or her best professional training and knowledge that there may be some kind of abuse going on when the child goes to see the other parent, what should they do? Okay, So the law says yisod savir la'aniach. The law says you have a reasonable suspicion to assume, okay, which is a hard test, difficult test to really determine what that means. However, my recommendation then would be to go to a social worker. In other words, what I like to say to people in cases that are gray is go to a social worker. You can go to a social worker or you can go to the police. And I think the police do generally a very good job, but I would go to a social worker. I would document that you went to a social worker for yourself. And if they feel, based on what you've told them, that there is something more serious going on here, then they have the ability to refer to the child to someone who's trained in this field. Okay? The question would then be, what if also, let's say on this, you're assuming it's in the dad's house, what if the mom objects to that? But I do think that in that case you do have an obligation to report. I want to get back to this, but I want to hear this question first.
What do you do if a client talks to you about what happened in the past? Let's say there was an abuse, they perpetrated an abuse 10 years ago.
Okay. The question is, what if your client tells you they perpetrated an abuse 10 years ago, right? Which is different if they tell you they perpetrated an abuse 2 minutes ago. So that kind of relates to the other question that was over here, but more acutely. I think that when you're treating someone, I think that you have to let them know that you have this obligation. And it may be that you feel in your gut that something like this might come out. You might want to say, these are the kinds of things that I would have to report. So that they're on notice. And I do know, actually interesting, someone who left a therapist because the therapist said, I have to report this. But it actually was very transformative for her afterwards that the report had been made. So you probably, if it's 10 years, I don't know, I'd have to check it, depending on the ages and so on. If someone confides in you that they did this, that's, then, obviously if it's recent, you for sure have an obligation. If it's not recent, you don't. And there's another question to that, which is, what's the impact on the 30-year-old, let's say, who was the victim at that time as well, which is more of a therapeutic question. But I'd have to check exactly what the statute of limitations would be about what that person is telling you.
And if you don't know who the victim was, they're just telling you what they perpetrated.
No, so if you don't know who the victim is, it specifically relates to the law. The question is, what if you don't know who the victim was, but the law specifically relates to a minor or a person who was somehow vulnerable at the time. So you have to know who that person was.
It's not, there's no responsibility to report somebody that you just feel may be a danger to society because of...
The question is, do you feel there's a responsibility to report someone who's a danger to society? No. The law says, Yisod Savir La'aniach. You have a reasonable assumption to assume. But I want to connect to what you said, and I think it's very important for people in this room. Your question was, what happens if in play therapy you think there's grounds to assume that something went on that shouldn't have gone on. So I do think you have to report it. Unless you're a clinical psychologist or someone trained specifically to do what's called to be a choker noar in certain areas, you are not qualified to diagnose that sexual assault took place. And if I sound severe about this, it's because I am. I've seen terrible, terrible damage done to families by people who are not qualified to make the determination and have made the determination. And when I say made the determination, I don't have a problem with anyone referring it to people who, this is their field. When you make a determination, and I've had people do this, and write a letter to a court and say positively, these children have experienced sexual abuse either by their mother or their father, A, you are causing tremendous damage to a family, and B, you're at risk professionally. I had a case like that, and the truth is, because the person wasn't actually licensed in the Ministry of Health, I couldn't file a complaint, which I would have done. So it was kind of ironic that the less qualified person was more protected. And secondly, my client wanted to sue this person. And I talked them out of it more for personal reasons, but you're at risk here, and frankly, you should be at risk. Because incorrect charges, and I'm not saying nobody should go to the social workers or the police if they need to, but making a positive determination is one of the more destructive things someone can do to a family. So you need to be really, really sure, and again, and to know what your qualifications are and what your qualifications are not. Yes?
I just wanted to clarify my obligation.
Yeah, no, I'm not saying you specifically, not for, no. I'm sorry, I don't know your name.
I'm sorry.
What's your name?
Irene.
Irene was just saying she just wanted to qualify with the laws. Yes, no, I wasn't, you gave me you pushed me on to something I actually had on my notes that I wanted to mention this because I feel it's so important.
But do I have actual obligation to go with a suspicion? Just a
Yes,
suspicion?
it's called, again, do I have an actual obligation to go with a suspicion? Again, the wording is Yesod Savir La'aniach, okay? Not because whatever, you got a bad feeling in your stomach, but you can substantiate it. Yes?
My question is two parts. Someone asked before about corporal punishment in schools. If a social worker is made to know that happened by family members based on what they heard from their children, how would you recommend that a social worker or other professional comply with the law in that instance when they know that this has happened in a certain school, certain teachers? And number two, this chovat divuach with the courts, how do they, what's...
It's not the courts. It's in the criminal code. Chovat divuach, the obligation to report, is to social workers or to the police, and it's in the criminal code.
So if a social worker is made to know
Yes.
of this corporal punishment, so number one, how would you recommend a social worker act upon that information?
Yeah, I can't give information on how the social workers should respond.
And is this in terms of our communities, is this a liability where someone did not go to the relevant authorities and report what they know? In terms
Okay, so the question is it a liability in our communities when a person didn't go?
Could it be for a person, but professionally, not to report it, but yet knowing that information? Because there could be consequences.
You cannot, as a professional, not report. Okay, not if you know about something general, but if you know about something specific and it comes to you in the course of your work, there's another obligation for regular citizens, you have an obligation to report.
So practically, like a Talmud Torah XYZ, you know that there's corporal
If you're treating a kid, right, and he comes to you and he says, my Rebbe hits me every day, yes, you have an obligation to report that.
And not if he says that the Rebbe hits other boys.
If the child himself, then that's a question of what's Yesod Savir La'aniach. What does that mean?
What if the child doesn't disclose you, but the parents tell you this happened, that they know this, their child has experienced this in the classroom?
Then the question is, what if the parents tell you? Look, I can give you my legal answer, and I can give you, we can discuss it. I've lived here nearly 40 years, and we are all aware, for better or for worse, of things that go on in certain communities, and the way we all collaborate with them to a greater or lesser extent. And the question is, the law says one thing, we're obligated to follow the law, and it's who's willing to break that and at what cost? Those are really the questions. It may be for a parent to report it. There are going to be consequences in their community. There are going to be consequences in their family, which is a different question than what the law actually says.
So my question to act upon it would be better for someone to approach the school, the institution, and give like a warning or something like that in terms of you?
Again, the question is, would it be better to approach the school and give a warning? And again, there's the strict letter of the law, and what's the smart way to act? What would be the most effective way to act? And
What you've seen from your experience, that's my question.
again, it really depends on the community. There are communities that close ranks. There are communities that close ranks around improper behavior. And the person who's trying to do the right thing gets ostracized. Not saying they shouldn't do it. But everybody has to be aware of what price they might pay and what they're willing to pay. I don't have a good answer for you because it's extremely circumstantial not from a non-legal point of view. From a legal point of view, there's an obligation to report. Okay? Yes?
Hi. In response to the gentleman in the front whose client confessed, I think from a therapeutic standpoint, confessed about that he was the perpetrator.
Oh, I see. Okay.
Yeah.
Okay.
So I think it's important from a therapeutic point, I don't know if you covered this, but in terms of to ask him why he's sharing that with you, and what does he want you to do with that? You're left standing with this very important information, like what would you like me to do now, you know?
Okay, so there was a comment here that with regard to someone who opens up and says they were a perpetrator, so the suggestion is to ask the person why they feel it's important and what they want you to do with that information at this point. And it may be a time where there can be some kind of reconciliation also if there's not a criminal aspect involved. Okay. Just want to... Okay. All right, I think that we have about 15 minutes left, so I could talk some more, or I could open up just to general questions that you may have from your practice, or questions about the legal system. What? Yes? Okay. Yes?
Are there any laws, let's say there's an agreement between the divorced couple and then, like, one of the parties is not following the agreement in terms of how they split the leave, or
Okay.
are there laws that you use to recommend it?
That's a very good question. The question is, assuming that a couple got divorced, they have an agreement, there's, let's say, some kind of schedule about parenting hours, and one party's not keeping them, what do you do? Okay, it's a very good question, because in the dysfunctional cases, it creates an enormous amount of conflict. And I'm going to step back a little bit and say, when I say the equality is killing us, what do I mean by that? I'm a big fan of equality for everybody, civil rights, personal freedoms, but I feel that the discussion, the obsessive discussion of equality and the obsessive discussion about what my rights are has led to a phenomenon of people looking at the clock with regards to children in a way that is making more difficulties for children of divorce today. What do I mean by that? I mean that people seeing the children as something to be divided up, and sometimes as a bit of a burden to be divided up. Why are they with me now? They should be with him right now. Okay, it's your kid. Get over it. It's a very problematic phenomenon. So, but more to your question was, what happens, let's say, if a parent sabotages visitation? A parent comes to meet a child, either after school, and the other parent's already taken him out of school, or comes to pick up from the other parent's house, and the kids aren't there, they just had to go shopping at that moment. What can you do? In theory, and people do this, you can go to the police. It's because if there's a divorce agreement that's been given force of judgment by the court, it's a court order, and that's a violation of the court order. Why do I say dysfunctional? It can reach really crazy things. If a kid, dad's supposed to pick up a kid and meet him at the bus stop where this bus drops him off, and instead the grandma picked him up, then true. mother filed a complaint to the police that he wasn't keeping the agreement. Okay? It can reach those levels again with the dysfunctional families. A question I get a lot is, what if the other parent's not taking the kids? So one of my answers is, you're the parent, enjoy your children. The other answer is, sometimes there are costs associated with it. So the courts have, actually, in rare cases, and it has to be worth it, have said, okay, now this person has extra babysitting costs because you are consistently not taking the children. I'm not talking about a one-off. You're consistently not taking the children, and therefore we're going to make you pay for this. The third option is to go to court and file a contempt of court order when the person's not doing it. Yes?
What do you think about the dividing the time the parents spend in the same house, like the kids?
Okay, so that's called, the question is, what do you think of dividing the time the parents spend in the same house? So it's called nesting. One parent goes out for a week, the kids stay in the house, the other parent comes back the next week. So first of all, you should know I made an agreement like that, and the Beit Din would not authorize it. They said that there are halachic problems with it. The couple asked their own Rav, and we circumvented it, and they did it. In any case, they were the best candidate I could have ever imagined for it, and for them it was really hard. It was really hard emotionally. So I think that, and I haven't seen anyone else do it, you need a certain amount of money, which again in Jerusalem we don't have, and you know, all of these models, and it may be my own skewed vision and my own practice, which is fairly high conflict cases, all of these models envision a divorce coming out of a situation where people just really saw they're going in different directions and don't really want to continue to do this. I don't get those people. You know, maybe they're going to mediation, or those are my mediation cases, which aren't that many. Or maybe they're doing things differently. But most people don't want to walk into the house and seeing their ex-spouse's pajamas in the back of the bathroom door. So it just hasn't taken off in Israel, and I don't think the studies that came out of the States are that glowing. Yes?
Yeah, I was just going to say, I know a couple doing that in New Jersey right now, but they have money, and it wasn't acrimonious, and it works very well because they have 2 teenage boys, and it just works
so
nicely.
this is a case
in Yerushalayim
in New Jersey, the family has money, the kids are 2 teenage boys, which probably made sense to keep them in their place, and it's working very well. I assume that there are a small number of cases where it can work fine. Yes?
Yeah, sorry, I have a specific question. I have a client who, the mother told me that the child who is my client was, apart from plenty of other abuse that has gone on, his head was smashed against the wall by a Rebbe about 3 years ago, and the Rebbe's still in the school.
Yeah.
So I have a duty to report that.
In my humble opinion, you do. The question is, did the child report to you? The mother told you?
The mother told me. I think she tried to do something in school, but it didn't work out for whatever reason. When I asked her about switching the kid's school, because he sees the Rebbe all the time, obviously, she said, well, it's the same everywhere, so what's the point of moving him?
Yikes. So here's a difficult question, really, because the question is, the child reported that the Rebbe smashed him 3 years ago, and the mother said there's no reason to move him because it's like that everywhere. In my humble legal opinion, you have a responsibility to report. Again, I would say not necessarily to the police, but to a social worker. I do. Yes?
What's your opinion about halachic prenups? Do you find that they make a difference?
Okay. And the question is, what's my opinion of halachic prenups? Okay, everybody knows what that is? Halachic prenups, which is basically an agreement signed before the marriage, and there's a structure in there, I'm not going to get into what the details are, which is intended to prevent situations where one side won't accept a get or one side won't give a get. Okay? I'm in Israel, I'm an agnostic on that issue because I think the Beit Din has powers here that they don't have elsewhere. The really, horrific cases I hear of people not giving gitin or accepting, more giving, are in the United States and maybe in other countries as well that I don't hear about so much. In Israel, where the Beit Din has powers, sometimes I recommend it, and lots of my clients want it. So I'll do it for them. It hasn't ever, to the best of my knowledge, been tested in a court here. Yeah, that's the best of my knowledge. I know there was a very successful case in the United States not too long ago, 4 or 5 years ago. And I think because of the inability to impose serious sanctions for failing to give a get, I think that in the States, it's maybe Canada also, it's very important. Yes. Oh, 1 second. Yes.
If a parent doesn't pay child support, do they lose their other rights in terms of education, medical?
The question is, it's a good question. If a parent doesn't pay child support, do they lose their other rights? And the answer is no. The answer is a very strong no. There's kind of a firewall in Israel between issues of parenting and issues of paying child support, so that I've had parents who haven't paid a penny in child support who have been very actively pursuing all kinds of other things and basically making the kids' life miserable in other areas. And it's a question. There are many advantages to that, and there are many disadvantages. There are some disadvantages to that. On the overall, I think it's a healthy divide, though. I do. More questions for you? Yes?
Yeah, going back to that example, if you have good enough reason to believe that the perpetrator or the Rebbe changed and he's not acting in the way he did 3 years ago.
The question is, what if you know that Rebbe or person or perpetrator, you have good reason. Look, you don't have to go to the police with everything. You have to go to either the police or the social worker. And that's a conversation to have. But it doesn't limit your legal responsibility. Okay?
And there's just another question, like, I always hear about Israeli law changing all the time.
Okay.
I mean, and I'm wondering about it, like, what you're speaking about, like, is this...
Okay, so the question was, I'm always hearing about Israeli law changing all the time, what you're speaking about. I don't think there were that many changes. In the last 2 or 3 years, they've been changes. One is the law I mentioned before, Chok Esder Dainut, the law that deals with the couple of families in conflict. The big change this year had to do with the Supreme Court decision dealing with child support. There's a lot of talk about changes. There's a lot of talk about changes, for example, in the area of joint custody. But it's the confusion is because we're importing foreign terms. In Israel, before there was all this talk in the courts of joint custody, it was very, I think kids saw their non-custodial parent a lot more than they do in other Western countries in any case. My colleague and I were once in a also a conference in America and heard how they divide up the weeks there, and they said, and we kind of looked at each other and said, well, we've been doing it that way for years here. There is a recognition by the courts and the system that both parents are important. There are those who say it wasn't sufficient, and only recently it's becoming more sufficient. It's not enough. But those are the changes right that I see happening right now. Yes?
In 368 Aleph,
yeah.
That was the responsibility of, as a citizen, to
yeah.
report something. So even though you're saying as therapists, we don't have a responsibility to, let's say, report against the abuser if you don't know the victim or things like that, where it's a danger to society, why don't we have that responsibility as a citizen of knowing somebody who is a danger to society?
Okay, so the question is, why is there a difference between a regular citizen's responsibility to report and a professional.
What I'm
Yeah?
saying is that even if we don't have the professional responsibility,
Right.
we should still have the citizen.
You still have you have the citizen's responsibility, but it's limited. It's limited to something that happened recently. Okay, it says in the Hebrew is zemika ovneva avera. Recently, you have good suspicion to assume that there was recently an offense against a child. And that's because we don't want to turn everybody in the state into, we don't want to be everybody tattletaling. If it's real, if it's recent, then you have that responsibility. It doesn't mean that, let's say, a neighbor comes to you and says, a year ago something happened. You could still go to the social worker. This is what your responsibility is as a citizen in the state of Israel.
So in the case of the Rebbe hitting the kid's head against the wall, that would be something that would be reasonable to go, even if you don't know the kid, just to prevent the guy still a Rebbe.
Always speak to social services or to, I mean, you might not want to speak to the police, but certainly social services if you have a suspicion of someone misbehaving. I'm going to take one more question, then we're going to finish. Yes?
I don't know what the financial outlay is of divorce, but if two parents decide to divorce, is there a do-it-yourself divorce?
Okay, there's a question, is it a do-it-yourself divorce? Do-it-yourself divorces are another thing that make me a lot of money because usually people make a mess of it. However, having said that, if you have two people who are on the same page, it's very easy in the state of Israel, it's very fast to get divorced. You need to write an agreement, and I would only write an agreement with a professional. There are children involved, there are sums of money involved. It's not something to be written on the back of a napkin, which people pay a price for that. But it's worth the investment of going to a lawyer and writing it up together. Once you have that, you can just get it confirmed in the court or in the Beit Din and set up a date for a get. The state of Israel is, and from what I see in other countries, one of the most efficient ways, if people aren't fighting, to actually get divorced.
They don't have to do some kind of therapy?
No. If you agree, you don't have to do therapy. If you agree to get divorced with your spouse, it's very efficient. Okay? All right, thank you very much.